Good morning. Welcome to Member Focus Monday. I'm Christina Schaefer, Director of Social Media for HAR, and we have a very important show for you this morning. So if you haven't yet, take a moment, like this video, go ahead and share it with other realtors, because the information that we're covering, as it's stated on the marketing material, is intended to keep you out of jail. So with that, let's go ahead and introduce our guests for this morning. We have Allan Van Fleet and we have HAR's Legal Counsel, Grant Harpold. Welcome, gentlemen.
Good morning.
Good morning, Christina. Morning, everyone.
Thank you. And thank you so much for being here today and taking the time. I know you're both very busy, but the information that we're discussing is so important for our members to hear. So with that, if we could just have you both do some brief self-introductions, tell us a little bit about who you are and what you do. And Grant, you've been on this program before, so we'll start with Allan today.
Sure.
Hi, I'm Allan Van Fleet. Most fully retired lawyer, and for over 40 years I practiced antitrust law and commercial litigation. And at one time I was the chair of the American Bar Association section on antitrust law.
Very good. Thank you. And Grant?
Yes, Grant Harpold, legal counsel for HAR, and been advising and discussing broker issues and related issues for 30 plus years, and still doing it, still enjoy doing it. Happy to be here.
Thank you. And Grant, you are an expert when it comes to this program. I think you are probably the guest that we've had on the most. So we always have something fun to talk about with you. So let's start off with some basics. Allan, if you could just explain to us, what are antitrust laws and how do they apply to real estate?
Sure. Basically, antitrust laws should be called pro-competition laws. And in every other country, they are called competition laws. Antitrust is the name we call them in the United States because of a historical fluke, which I'll talk about in a moment. These are laws that come down against all types of behavior and structures which interfere with free competition, which is the fundamental groundwork for our capitalist system. We have federal antitrust laws and we have state antitrust laws. There are two basic kinds. One is an anti-monopoly provision. In the federal law, it is Section 2 of the Sherman Act, and that goes after very, very large enterprises that are so large, that have so much impact on the market that they can raise prices, suppress prices, limit output just by their own behavior. These are the laws that both the federal government and many state governments, including Texas, are going after the big tech companies. The case against Google, against Amazon, against Facebook. Those are the anti-monopoly provisions. But there's another way that you can unduly affect the market, harm competition in the market, even when there are many competitors. And that's when competitors get together and agree on the prices they're going to sell at, the prices they're going to pay to workers, the territories they're going to compete in and not compete in. Dividing up customers, anything that impedes free competition like that, they're sometimes known as anti-cartel laws. And the reason they're called antitrust laws in the United States is back before the Sherman Act was passed in 1890, you had cartels of railroads, of steel producers, of tobacco companies that actually would take their voting shares, their stock, and put them in the hands of a trustee, a big railroad trust, a big tobacco trust. And in order to go after those trusts, the Sherman Act was passed to bust them up and to penalize those kind of agreements, so that the law says something to the effect every contract combination in the form of trust or otherwise in restraint of trade is illegal. It's a felony under federal law. It's a felony under the Texas Free Enterprise and Antitrust Act, and every state has its equivalent of its own antitrust laws. They can apply to real estate and every aspect of real estate where folks compete. Obviously, for the listeners on this program and for this organization, they have been used to go after agreements among brokers that we're all going to charge 6% commission. We're all going to charge a minimum of, say, $10,000. As I say, it has been applied. It is being applied now, and there are investigation of agreements among brokers to either limit the customers they'll go after, to limit competition in the form of commissions or otherwise. In related areas, a couple of years ago, both the federal government and the California Attorney General went after bid rigging conspiracies amongst folks who would go to foreclosure auctions, how they would rotate the bids amongst themselves, how they would agree not to pay more than X, how they would agree not to bid against one another. The Texas Attorney General, a few years back, using the anti-monopoly provisions of the Texas law, went after a title company here in Houston. So these laws can apply to any aspect of the real estate business.
Excellent. Thank you so much for explaining that. And I wanted to kind of get into a little bit of definitions with us, because we hear some of these phrases and words being tossed around and maybe people don't quite understand what they mean. And along those lines, Grant, we had a discussion last week about boycotting or implied boycotting. Can you explain what that is to us?
Yeah, and I like what Allan said early on in his discussion, which was a great overview. He said get together, which means it doesn't require a written agreement. It literally means getting together or discussing or having a dialogue about being, conducting a boycott or trying to restrict competition. And on a boycott, we're talking about two or more individuals or entities getting together to restrict somebody else's ability to compete. And so let me give you an example. Let's say I'm an MLS member and I put an offer of compensation out there on the MLS for $1. That's my offer of compensation on the listing side. And some other members on the buy side perhaps say, gosh, wow, look at that. Let's not do business with that person, or let's not take our clients by those properties, or let's do something that would cause that competitor, that other member, to raise their commission offering. And so that's sort of the beginning or the pretense of boycotting, is that you're getting together with somebody or some entity in an effort to restrict the competition of somebody else who is also in the same playing field, and causing them to do something to, in this case, to increase their commission. And which ultimately, and the goal here is to not hurt the consumer, which in a lot of people's eyes that could hurt the consumer. And so that's the goal here, is to protect the consumer. So that's sort of the simplistic view of what can happen and what might happen on the genesis of a boycott.
Yeah, very good. Did you have anything you wanted to add there, Allan?
No, I think that's an excellent summary.
Okay, very good. Yes, I'm sorry, go ahead.
I'm good.
Okay, well, my next question is for you, Allan. And what is, again, trying to define some things here so we all understand what we're reading when we read these articles on NAR's website or other places. What is the FTC and the Justice Department, and what are their goals?
Sure. Let me take that in reverse order.
Okay.
The United States Department of Justice is our chief law enforcement agency. It's a cabinet position. It's headed by the Attorney General. And the Antitrust Division is headed by an Assistant Attorney General. That's one notch lower from the Attorney General. Their goal is to investigate and prosecute violations of the federal antitrust laws. They do this very effectively. If you want to have some interesting homework on this, I suggest you and your listeners go watch a movie during the week or the next weekend. It's called The Informant. It's with Matt Damon, and it follows the investigation and what can go very, very wrong when you get caught up in an antitrust conspiracy, a get together. As I said, it's called The Informant. It's by far and away the best movie made about antitrust there can be. And it shows you the wiretaps, the turning people on one another, the type of methods that the Department of Justice uses to prosecute these crimes. A violation, if you're found guilty of an antitrust violation, the fines can be up to $1 million for an individual, $10 million for a corporation. And here's this catch-all. It can also be twice the gain or twice the loss caused by the violation, such that the Justice Department has gotten fines literally in the hundreds of millions of dollars. But actually, the Justice Department has said very openly, we don't think fines are a good way to deter anti-competitive behavior, this getting together to fix prices, to divvy up markets. And so for several administrations now, they have insisted on seeking jail time for the individuals involved in antitrust conspiracies. And if you're not prepared to do 36 months in a federal prison, don't do the antitrust crime. The Federal Trade Commission was created at the turn of the 20th century to be more flexible, more vigorous in pursuing antitrust violations. And often the jurisdiction overlaps. The Federal Trade Commission has 5 commissioners, all appointed by the president. They have to be a mix of political parties. They have an excellent staff of economists and lawyers, and they sometimes will seek to, go after practices that maybe have not been, determined by the courts to be actual violations, but we know it affects competition badly and broadly. And we're going to look into those. And while the FTC has no criminal penalties, they can't put you in jail. They can fine you up to, it's closing in on now $45,000 a day for every day that they determine you are in violation of the laws. The president, you may have seen recently, issued an executive order calling on all agencies of the federal government to go after anti-competitive conduct, to increase competition in all areas of our commerce. And you can be sure that the Federal Trade Commission is going to be at the spearhead of that effort. But I don't want this answer to let anybody forget about the state antitrust agencies. Texas has a very vigorous antitrust division of the consumer protection section. And in fact, it is the Texas antitrust division that is leading the state effort going after Google right now. I know most of the people in that section personally, including a former associate of mine, and they are absolutely top-notch folks, and every state is going to have its own division like that. And lest you think, that, well, I only operate in Harris County, nobody's going to look at that in Washington. One, you're wrong about that. They are looking at it in Washington. There's a division of the Federal Trade Commission that has an office in Dallas, for example. But even these smaller conspiracies, the state antitrust divisions are always looking to go after local conspiracies.
Okay. Very good. Thank you. So I think it's easier sometimes for us to understand, and if we have kind of a picture painted out for us. So are there any examples of antitrust violations that you both could share with us?
Yeah. Well, there was of course, this is always ongoing, and as Allan said, it can focus all the way in on Harris County. It doesn't have to be some broad nationwide group effort. It could be something happening in Harris County. But I want to, you should have a screenshot of an example of a recent case involving the government against certain chicken suppliers. If you could show that on the screen.
Yeah, absolutely.
And so and the reason we're showing this is just to show how simple the communication can be. So here in the very top here, the incriminating message. This was an email sent by one of the chicken suppliers to another chicken supplier. And if you focus on the second sentence, I think that's really kind of incriminating within that email. And it was, they have been adding market share and still trying to do so. Selling cheap chicken and being short doesn't make sense. So I mean, you're looking at that saying, well, that doesn't really say a whole lot. Well, actually, it does. And so that was sort of one of the lead emails that started the investigation. It ended up being a critical email, and there were other emails. And there were, to be honest with you, this communication, there wasn't a whole lot of it. And so the point is that it's this sort of subtle, or what somebody might think, subtle conduct that is inactionable or not under scrutiny, that is under scrutiny and can be examined by the government, can be used against you. And here we see it here. In fact, look at the next email was the response from one of the executives saying, basically, don't tell me. So, from applying it to where we are, I mean, just because you're a broker and you don't know what's going on, or you refuse to get involved with what's going on with some of your agents, that's not a defensible position. Because here, taking the position, don't tell me or I don't want to know, did not save the executives involved. And in this case, ended up being civil and criminal penalties. And so there's sort of a hypothetical that could happen here in our community, just language to that effect, that just back to trying to protect the commission and writing something like we put in this hypothetical that could lead to an investigation. And then the very last part of the display here is what the Justice Department said, is that, like, gosh, this sort of simple communication was basically a layup for the government to prosecute the case. And so it's real, and it happens, and it's ongoing.
Okay, very good. Do you have anything you want to add here, Allan?
No, I think this is a very good example, and as Grant hinted just a few minutes ago, it doesn't take a lot to prove a conspiracy. The jury instructions on what it takes to form an agreement, a conspiracy, are really somewhat frightening. It can be done with a nudge and a wink. Somebody puts out there, listen, anybody'd be stupid in this market to charge anything less than a 6% commission on a whole deal. People are dying for houses. They're going to pay anything to get there. That's one person's opinion. But another person chimes in and says, well, I'm not stupid. There's your conspiracy. There's your agreement. Mm-hmm. We talked about the government agencies and investigating and the jail time, the high fines that can come from it. But let's not forget, most of the money that antitrust defendants fork up comes from civil actions, class actions by consumers, those who think they've been harmed by the conspiracy. They have the opportunity to sue for 3 times the damages they can show, and it is not an exacting formula to prove those damages, plus their attorney's fees, plus costs of courts, and it's often these follow-on civil suits, including class actions, that end up bankrupting companies. Some other examples, in the Houston area, we had some folks who were caught up in the grand conspiracy around the world to fix the prices of parts that were sold to automobile manufacturers, right? Mm-hmm. We may see something like that again. That investigation and series of trials took several years through the Bush and Obama and part of the Trump administration. We may see that again as auto parts are in short supply, particularly chips you may have heard about. There was another one that was busted right here in Houston. It doesn't sound sexy, but the makers of marine hoses, those hoses that will go, say, from an offshore offloading
Oh, I think Allan froze on us for just a second. While we wait for him. Oh, here we go.
We back on?
Yes, we cut out
Do
for
I need
just a
to back
second.
up, Christina?
If you don't mind, yes.
Sure. I was going to say another conspiracy that was literally busted right here in Houston during the offshore technology conference was the manufacturer of marine hoses, these large kind of rubberized hoses, flexible hoses that you attach to an offloading platform and get the oil, the petroleum products, the LNG onto shore. The manufacturers of those around the world had conspired to fix the prices that were sold to private and governmental terminal operators. One of the conspirators, much like Matt Damon in the movie y'all are all going to go watch, got scared, went to the government, got on a wire. They rigged up a hotel room here in Houston with cameras, got everybody on camera, and busted them here. I happen to represent two British officials corporate officials who participated in that. They spent a lot of time under ankle bracelet arrest in Houston before they were extradited to Britain, where they were prosecuted under the English competition laws.
Okay. We have a few questions that have come in from our members, and somebody just said, please give real estate examples. We really wanted to try to avoid specific real estate examples, so we weren't calling out a specific brokerage or anything like that on this program, but we do want to address some of the questions that have been coming in, because obviously this is a very hot topic right now, especially. We've seen so many questions about this from members. Lisa said,
Christina,
I'm sorry, go ahead. Yes.
If you wouldn't mind my interrupting, and Grant, I'm sure will say this too. Y'all all know about the attorney-client privilege, right? When you talk to your lawyer in confidence, in private, to get advice on things. This is not one of those private conversations. We're obviously going out over Facebook Live. I'm an antitrust lawyer. I'm not your antitrust lawyer. And well, Grant is the lawyer for the association. If you've got a specific question and concern, right, pick up the phone and talk to Grant. Let's not do it over live social media, right?
Yes, very good. So these questions have been asked somewhat generally, so we can address these. And one that came in from Lisa is, what is the best way to document that we've conveyed this to our client and the client will be responsible for paying our commission? So what is the best way for them to do that?
Well, I think anytime that, whether it be a conversation about commissions or any material aspect in a transaction, followed up with an email, some sort of confirmation of your discussion. And so now, it used to be you put a note in the file, or even you wrote a letter, but we're beyond that to some degree. You can always still stick a note in the file, but confirming with an email, whether it be on this subject that we're talking about or some other issue, like I said, related to on the buy side or the sell side, a confirming email is still works and still, is probably the best practice.
Okay, excellent. Michelle asked a question. How would you, and again, you're not giving them legal advice here, but if you could share just how would you prove your listing is not being shown by agents, and maybe it's because you're offering a different offer of compensation than what they are wanting?
Well, I think that's part of what we're doing here today. I think your proof could be found in social media, and that's sort of our message today is be careful about what you say on Facebook or in an email or any sort of social media public discourse of conversations or information or wherever publicly somebody can see what's being said. I mean that's kind of what you have to be careful of, and choose your words. The whole point of all of this is not to and I mean, I guess to some extent is to not get in trouble, but really the whole point of this is to serve the consumer. We're here to help the consumer have informed choices and to not be, artificially driven up prices or something that causes damage to the consumer. And that's ultimately the goal of all of us, is to serve the consumer in a fair and reasonable manner.
Okay, very good. Our president and CEO, Bob Hale, said, can you discuss the implications of posting on social media? But also Demetria said, is merely informing colleagues of various agent or builder commission amounts a violation? Would you not agree that we need a platform for information? Then individual agents can function as they wish. So where do we cross the line of information to a violation? And is posting on social media one of those examples?
Well,
this is a difficult question in antitrust, and it virtually every conspiracy, centers around this fine line. Mm-hmm. Let me say, if everybody came to an independent decision that 3% was the number, we worked out the mathematics and the economics, and this just happened to be the right answer. Even though everybody sells at the same price, and most commodities are sold virtually at the same prices because the economics affect everybody individually, that mere parallel pricing, parallel conduct by itself is not an antitrust violation. There has to be parallel conduct plus in fancy antitrust jargon, but that plus can be very, very, it doesn't take much. Mm-hmm. Somebody can say, here's what smart real estate brokers charge. Or, historically, we've charged 3% aside. Historically, the deal has been 6%. Signaling that kind of thing, that this is what smart brokers do, this is what brokers traditionally do, there's no reason to break from tradition, that will get you in trouble. Mm-hmm. That kind of price signaling, that kind of, I don't know what anybody else is going to do after listening to Grant and Allan, but I'm sticking to 3%. All it takes is someone to say, right on, we're doing that. And this is an aspect of our business, of your business, that is under intense scrutiny. Y'all read the Chronicle. The Chronicle went out of its way to find out how our brokerage commissions or prices set around the world. The United States has the highest in the whole world. It has a rigid structure of this 6% that I'm not a biblical scholar, but I don't think there's anything in there that says it has to be 6%. Anything that suggests out there on social media or otherwise that this is what it is, and anybody who deviates is really stupid, is just setting yourself up. Particularly the Federal Trade Commission, they want to see mavericks in an industry. They want to see somebody come in and shake up things and come up with innovative pricing, innovative marketing, innovative ways of handling sales. And just because you're used to a certain compensation package, suggesting that that's the way it is and the way it always has to be is just inviting trouble, in my opinion.
Absolutely. We also, and this might be a little too hypothetical for us to be able to answer, but a few people were referencing increase in builder prices. How are builders who are canceling contracts days before a buyer is expected to close and then requesting an increase in sales price because of an increase of materials without any proof of the increase of the price of materials? How is that going to be dealt with? And Kareem also added in his comment that this is putting consumers at risk. So do you have any thoughts on that?
Let me just say what Allan just said. His summary just moments before was, I hope everybody heard that and will listen and go back and watch it again, because that was so well said and so applicable and so usable and so simple. Even mean, even I understood it. And so, so thank you.
That's what I usually say, Grant. Even I understood it.
That was great. But back, so I think that issue may be a little bit beyond the scope here. It seems if that seems like a contractual issue, perhaps between the builder, seller, and the consumer buyer of that particular property. If the builder doesn't come to closing or wants to redo the contract or cancel the contract, it's really a contractual provision. Still, the antitrust still applies to all that, but that sounds like more of an issue of the terms of the contract and whether that builder or that seller can do it or not.
Okay, very good.
I think Grant is right, and I will bring an antitrust angle to it at the end. It is on an individual basis, a contract issue for the individual consumer. If you've got a builder who's repeatedly doing this, it may become a consumer protection issue. The Federal Trade Commission, the Texas Attorney General's office may well investigate a pattern and practice that is anti-competitive, that is just screwing consumers. Individual brokers may say, this builder has now walked out on 3 deals that I worked hard to put together. I'm not bringing that builder any more of my business. And that's fine. What's not fine is if you then go on social media or get together with some of the officers of HAR and said, you know what, we all need to stop dealing with that builder. That's when you cross the line. Instead of an individual's decision not to deal with a bad builder, it becomes a collective decision and a boycott, as Grant told you about.
Demetria just asked for a little clarification. So to clarify, informing colleagues is not a violation. Agents just need to withhold communication of their plan of action. Is that correct?
That's
price signaling can be one of the... Go ahead.
You have it, Allan. Go ahead.
Well, I was going to say price signaling is a very common plus factor that they'll carve together even without the acknowledgement that, hey, 6% is the norm and we're all going to do it, just signaling that, by the way, I'm not going to deviate I don't care what new people come into the market. I don't care what my colleagues are going to do. We're just sticking to the 6%. That kind of signaling, particularly if it comes from a leader in the industry, and then you see others following, that kind of behavior can get you into trouble. It's often not enough in itself. We often see, or at least used to see, airlines announcing price increases. One would do it, and then the others would follow. There have been investigations about that. Sometimes a violation is found, sometimes it's not. But telling you have no business. What legitimate business reason do you have communicating with your colleagues what your prices are going to be? You communicate that with your clients. If it said, mine is 3%, you don't like it, shop around. It's that ability to shop around that is the essence of competition and the essence of what competition laws, antitrust laws want to preserve.
All right, very good. Thank you for that explanation. I have a few more questions. We're going to keep moving here. So Grant, if you could share with us, what is the status, kind of switching gears a little bit, but what is the status of the lawsuits taking place in our industry right now, and where can realtors get more information about them if they want to stay up to date?
Well, there's half a dozen or so lawsuits still pending, still in the early stage, and so they're attempting class action status, and in theory, one aspect of the lawsuits is on the seller side, that the seller is paying too much on a commission to its listing broker because of the MLS rule of offer compensation to the buyer's broker. And then there's another side of the lawsuits where the buyer, the plaintiffs, are saying, well, we've paid too much for the price of the property, the sales price of the property, because of the offer compensation rule, causing the seller to have to raise its price in order to pay the listing broker. So it's on the buy side, it's on the sell side. All of those are still very, early on in their development, and look to be around, or look to be going on for some time. And so there's no real, you know, class action certification just yet, but that's sort of the next step in these series of lawsuits that are pending, and they're pending against NAR and some of the leading national broker franchisors. That's currently who are the defendants.
Okay. Very good. So, and Allan, I want to toss this one to you. Last week, the Justice Department withdrew its consent to the settlement that was reached with NAR in 2020. What does this mean for realtors and the real estate industry?
Well, the main thing that it signifies to folks who are listening in on this broadcast is that this industry is under the microscope of federal antitrust officials. Whether there was a miscommunication about the practices that NAR agreed that they would change, and whether that completely settled everything in the investigation that the new Justice Department wanted to look at, or whether there simply was, there's a new sheriff in town, and what the NAR got away with before and was the subject of an all-encompassing settlement is not how we see it. We want, yes, we will settle these particular practices, but we want to be free to look at others that are not specifically covered by this settlement and not have a clean slate, because we think there are more problems there. The NAR disagreed and said, no, this was a complete settlement. We're not going to agree that these things were wrong, and we're going to stop, or not admit that they were wrong, but we're going to stop it if you're still going to investigate it. And in the end, the Department of Justice, as the proposed consent decree allowed, said, then we just walk away from it. The details of it, particularly since it's no longer a settlement, it's worth looking. It's definitely worth looking at and see the type of practices that the Department of Justice has considered to be anti-competitive, and judge your own behavior or collective behavior by that. But the main thing to take away is that this is a very active, ongoing investigation, and the chief antitrust enforcers are looking at a variety of practices that they believe may impede competition in this industry.
Okay, thank you so much. So this is the very obvious question here, and this is actually a big part of why we wanted to have you on today. So Cherie said, what about when a few realtors speak about a builder who's decided to pay no commission and they say, stay away from that builder? By everything that you've discussed with us today, I would say that is a very bad thing, right? Yes.
Right, Allan?
Yeah, that's exactly what a boycott is. We collectively decide we're not going to deal with this person. The word boycott actually comes from the name of an Irish landowner who, by all objective means, treated his tenants just terribly. And the tenants got together and said, by God, we're not going to work for Captain Boycott anymore. That was a boycott. And regardless of your motives, including that this builder isn't paying us what we think we should be paid, that is intended to raise the prices. It is precisely the kind of boycott that the antitrust officials are going to go after. And, the advice is simply do not do that.
Yeah. And that applies to social media, to email, to verbal, everywhere?
Listen, watch that movie with Matt Damon. When you're sitting at Olive Garden over white wine with 4 others of your brokers, you don't know who might be wearing a wire. You don't know who might be at the next table. So just because it's not in writing doesn't mean it's not going to be prosecuted. Even if you think you are so in the right. I mean, one of the latest ones that both the Department of Justice and the Texas Attorney General went after were book publishers who got tired of being screwed down on the price that Amazon was offering books at, that Apple was offering books at, and they got together in a series of dinners in New York City, and somebody ratted on them, and they all ended up paying very hefty fines because they thought, and some would say rightfully so, that the big players like Apple and Amazon were offering books, the hard-earned work of authors, at too low a price.
Yeah. All right. So we've discussed so much today, and you've really helped clear a lot of this up. We obviously want all of our members to behave in a way that is going to keep them out of jail, as we've discussed here. Grant, I do have one more question for you, and I'm somewhat surprised that it wasn't asked by our viewers today, and that is about a minimum offer of compensation in the MLS. This is a question we see all the time, or there's an implication that HAR needs to create a minimum offer of compensation for it to be listed in the MLS. Can you share with us your thoughts on that?
Well, there has to be an offer of compensation, but there is no minimum, and there is no rule that allows for a minimum. And again, because the point is to have competition, and for that price or that commission or that amount to be determined on an individual case-by-case basis, and not to be preset or predetermined by a collective group of people not involved in the transaction. Because ultimately, again, the goal here is to serve the consumer and to be competitive and have a product that the consumer can afford and best enjoy. So that's why there is no set minimum.
Okay. Well, from both of you gentlemen, I mean, we're nearing the end here, but I would love to hear just any final thoughts or words for our members, kind of recapping everything we discussed today. And we can start with you on this one, Allan.
Sure. The one takeaway: do what's best for your business, your brokerage, but make it your decision. You go out and compete the way that you best think it is for your business, but make your decisions on your own, not as a collective, not as a group, and you'll be just fine.
Okay.
Yeah, I mean, listen to what everything Allan said. I mean, he laid it out so perfectly today. Go back and play this, reread it, re-listen to it, whatever. It was wonderful. I mean, and just think about the next time, whether it's a sit-down dinner at the Olive Garden or on social media, think about what you're saying. I mean, why would you be saying this about this particular member or competitor or industry or whatever it might be? Think about the real intent of why you're letting or expressing these words, and because a lot of times it really involves money and somehow to make that better, perhaps for you unintentionally, and so that's what you want to avoid. This is not, be careful about what you express and make sure that it's something that's pro-consumer and not just about you or your situation.
Okay, well, very good. Again, thank you to both of you for your time this morning. This has been very educational, and I know we did have some people that tuned in just a few minutes late. Once we finish here, you will be able to re-watch this from the very beginning, and as Grant said, maybe rewind and re-listen to some parts that Allan discussed some really important information for you that we hope you will take with you from this moment forward. So thank you again to all of you for tuning in. Thank you, Grant and Allan, for your time. And I do want to let everyone know that next week we will be joined by HR's Director of MLS, Sean Dauphine, to talk about Matrix MLS and some new features and some new tools that are going to be available to you very soon. So be sure to tune in next Monday at 9 a.m. Have a great week, everyone. Bye-bye.
Thank you, Chris.